Ladies and gentlemen, thank you first for coming here to join this conference. And I'd like to thank the organizers to allow me to be here and present results of my research during the first block of this conference, because within the research group, as we have discussed the topic, I understand that actually I should be the last one, because my topic is about UN, and the rules within UN are more political than within EU different institutions. I'll explain what I mean by that. So thank you very much for your understanding that I have to present results of my research now. It's not properly seen by me, but hopefully for you.
Yeah, we are going to solve it.
So United Nations and the rule of law with a special focus on relevant human rights committees and special rapporteurs. When I was invited to join the research group, and I was told to talk about concepts, enforcement and sanctions, and I wanted to do the research on UN. With my previous expertise, I looked at it and I said, okay, so sanctions, well, it does not work this way at the universal level. Nevertheless, as for today's presentation, I really would like to focus on concepts, enforcement, and sanctions. As for concepts, I'll call it for today, concept of UN. I will not focus so much on the rule of law, just really what that means within the UN, and I'll try to focus on human rights committees and special rapporteurs, because that's the focus of my research. So concepts first. United Nations, as we all know, it's a political organization, and it's an intergovernmental organization. If you remember from your public international law courses, then it is the states who adopt the rules, who enforce the rules. And there's a special feature of international law. You do miss a central enforcement mechanism, and it does have impact also on the understanding of the rule of law, even within the focus on human rights committees. We also know that the UN is about cooperation, and the main aim is international justice and peace. So what does it have in common with the rule of law? As for the monograph, when we started writing our chapters, I've included also a subchapter on the rule of law as such, and I've been said that previous chapters will cover it. So I've included only really like schematic understanding of the rule of law and the fact that as for UN, it is about justice, equality, and accountability. We do have, I call it like a definition or understanding of the rule of law at the international level, at the UN level, that was actually presented 20 years ago in a report of the Kofi Annan. And at that time, if you can read it, I just would like to focus on that equality, independence, and the issue of the consistency with international human rights norms and standards. That's the integral part of the understanding of the rule of law at the UN level. And it is understood that the rule of law extends to UN dedication to human rights. It does have some special institutional background, but my focus was supposed to be Human Rights Committee, so I haven't included that much into my today presentation. What I would like to include, and I would like to thank especially for the keynote, that I am a lawyer, so I am professionally deformed as a lawyer. If I'd like to see rule of law, I've got to understand what the legal norm is. So what I did research upon in my subchapter was a question whether the rule of law as a concept could be understood as an example of general principle of law. Again, if you remember your public international law courses, the question is actually, is that a source of law? because according to the ICJ Statute, Article 38, general principles of law are a source of public international law. So the question might be, or the answer to this question might then help me to understand the application possibilities of rule of law concept within UN bodies. Well, easy question, not that easy answer, because general principles of law within the international law understanding, these are unwritten principles that are present within national legal frameworks. And that's why I thank for your question, because then the question is, are we talking about the same when we talk about rule of law within different national legal frameworks? And the answer is actually not really. So for UN, as it has been also very well covered by Dame Rosalind, former ICJ President Higgins, they started talking about rule of law because that was necessary. It was modern. It is politically very welcome to talk about rule of law. But what that actually means, if we talk about human rights committees and special rapporteurs. Do you know how many times human rights are mentioned in the UN Charter? Just guess. I'm not going to ask every single of you. Just 1, 2 guesses if possible. There are not so many numbers in the world.
Millions.
0? Okay, millions. Wow, what a range. Any third, maybe that will be the... Okay, just help from 0 to 10. Try a number within that range. Actually 7. I've included also preamble. So 7 times. So already in 1945, when it was clear that UN was established to be political organization to help cooperation about states, only 7 terms it was there. But it was there. And individuals accepted that it was there, and they expected UN to protect their rights. But that was not the main aim of the UN. It was a political organization. So as for institutional background, it is true, and I've included examples of my research in the chapter, that as for human rights understanding of the whole concept and everyday institutional work, human rights are important. You can see that in work of all those 6 main human bodies, including. However, as for individuals, if you check the mechanism, there are very weak, soft law possibilities. I have distinguished charter-based mechanism and treaty-based mechanisms because, as for the topic I was given, committees were supposed to be included and special rapporteurs were supposed to be included. And now I'm coming to that part, because as for charter-based mechanism, you might have heard about Human Rights Commission that has created a mechanism of country and topic special rapporteurs. However, it has become really politicized, and therefore in 2010 it was replaced by Human Rights Council. And nowadays the mechanisms that had been used are used as well, including those special rapporteurs. We do have 12 country rapporteurs and 48 topic special rapporteurs. I've included the special rapporteur on independence of judges into my subchapter, because there's nothing like special rapporteur on the rule of law. And afterwards I focused on the work of treaty-based bodies. So apart from Charter, we have other human rights conventions that have created human rights committees, and that was supposed to be the focus of my work. And these committees were created by conventions, focuses on protection of either vulnerable groups or trying to eradicate some very dangerous concepts in human life, like torture, racial discrimination. But as for the vulnerable groups, children, that will be definitely the part of the LLM on children rights, and also women protection and persons with disabilities, migrant workers, and also persons who have disappeared enforcibly. So these are committees that have been created by international convention. It means their authority has been created by an international treaty, and you can expect that the state parties to those conventions wouldn't authorize these committees with like strong position. They do have authority to accept and require country reports. There are several different ways how to submit individual petitions, and these committees do adopt general recommendations. All these opportunities are considered to be control mechanisms. However, the result of them, that's recommendation. And that's the biggest problem. We are talking about rule of law, but these recommendations are not legally binding. They are really politically very persuasive, and states don't like to be on the table of discussions of these committees. However, they are there. And if you remember, those who have been here, I mean the first conference that has already been mentioned, I have included a comparison of how these recommendations as a result of individual petitions are considered what is their place within Slovak legal framework and Spanish legal framework. Because that's actually the understanding how theoretically the issue of sanctions might be considered. Legally speaking, I'm a lawyer. If I focus on interpretation of international treaties, what a recommendation is, and if I compare these conventions that have established human rights committees with, for example, the European Convention on Human Rights and Fundamental Treaties and Fundamental Freedoms, it is clear that Strasbourg Court adopts judgments. Committees adopt recommendations. They are not legally binding. However, individual state parties might understanding in a different way. And therefore, for example, there have been decisions of Supreme Court, for example, in Spain, who have declared that, yes, this is legally binding. And if I compare constitutions of both states, Spain and Slovakia, I wouldn't see the difference, but the Supreme Court in one of those decisions has decided, yes, it is legally binding. So it is very important to take into account, as for UN understanding of rule of law, how the relation between international and national legal framework is included. And when I finished here that part of my research and I came here and we discussed the issue of sanctions, I said, I'm really sorry, but there is nothing more about sanctions from the legal point of view. So if we are supposed to cover all three sections, concepts, enforcement, and sanction part, I have to include something else, and I have discussed it, and I've been allowed to present something from the, let's call it, opposite point of view, because UN has been established to secure international peace and security, and it does say that human rights are very important. Nevertheless, when it adopts sanctions, it might cause, and it has caused grave human rights violations by applying Security Council resolutions. And it has been clear, it has been on the table of different conferences and political representatives for ages. well, yes, for ages, since 45 actually. Nevertheless, it was only in December 2022 when a special resolution, UN Security Council resolution, was adopted that has finally formally applied the concept of humanitarian exceptions, because these are very important in case that there are Security Council resolutions blocking, for example, delivery of essential aid to civilian populations in sanctioned regions. And that's why I wanted to look at the issue of sanctions from another point of view, and that's the final part of my research within this research group. Thank you for your understanding, and thank you for your attention, and if you have any question or comment, I look forward to them. Thank you.